What assets can you keep when you go on Medicaid? When planning for long-term care, knowing what assets you can keep while applying for Medicaid in New York is a crucial part of safeguarding your financial stability. Many individuals fear they must give up everything to qualify for benefits. The truth is, with accurate information and preparation, you can protect much of what you've worked hard to earn. Navigating Medicaid's asset and income limits can be overwhelming. Misunderstandings about eligibility can lead to costly errors. For example, people often believe they must spend down every dollar before qualifying. But certain assets are considered exempt, and proper planning can preserve wealth while still securing coverage. The guidance of a skilled attorney is essential to avoid penalties and disqualification. Law and legalities of Medicaid eligibility in New York. Medicaid is a joint federal and state program designed for individuals with limited income and resources. In New York, Medicaid eligibility is determined by evaluating both income and assets. As of 2025, the income cap for individuals is $32,396 and $43,781 for couples. Nearly all forms of income count toward this limit: wages, pensions, Social Security benefits, annuity payments, and more. Asset eligibility follows strict guidelines. Medicaid classifies assets as either countable or exempt. Violating these rules, like transferring property without proper planning, can trigger penalties under the 5-year look-back period. A lawyer familiar with Medicaid law can help structure assets to comply with these rules and avoid unintended consequences. What assets can you keep when you go on Medicaid? Despite strict requirements, New York Medicaid allows individuals to retain certain assets. A primary home is exempt if the applicant, spouse, or dependent lives there, provided the home's equity is below $1,097,000 in 2025. One vehicle, regardless of its value, is also protected if it is used for transportation. Applicants may also keep personal belongings, furniture, and household goods. Retirement accounts and payout status, irrevocable burial funds, and life insurance policies under $1,500 in face value are exempt. For those with a spouse, the Community Spouse Resource Allowance allows the non-applicant spouse to retain up to $157,920 in assets. Understanding the process of Medicaid planning. Medicaid planning is the process of structuring finances to meet eligibility while preserving wealth. This often involves creating irrevocable trusts or purchasing Medicaid-compliant annuities that convert assets into income streams. However, these tools must follow strict criteria to avoid disqualification. Prepaid burial plans, structured correctly as irrevocable, are protected. Spend-down strategies are another option, using assets to pay off debt or buy exempt property. Timing is key. Improper asset transfers within the look-back window can delay eligibility. A qualified attorney can assist with the application process, appeal denials, and navigate complex scenarios, such as protecting a spouse's financial well-being. Consulting a law firm early provides more options and greater peace of mind during the transition to long-term care. Don't let Medicaid rules jeopardize your assets or your future. The law firm of Schlessel Law PLLC is here to guide you. For personalized Medicaid planning, call 516-574-9630 or visit us at 34 Willis Avenue, Suite 300, Mineola, New York, 11501, United States.